May I please, Lordship? Lordship, I'd like to mention item number 8, Lordship.
Item number
8.
8. Yes.
Lordship, here, the leading counsel is from Gauhati and he's in bereavement, Your Lordship. So I've taken the consent from the other party also. If this matter can come after 2 weeks, Lordship.
Learned Counsel Mr. Medovero submits that the leading counsel is from Gauhati and he's in bereavement, and accordingly prays for listing the matter when
After 2 weeks, Lordship.
after 2 weeks. Learned, you are for
Respondent number 2.
respondent 2. Okay, Learned Counsel says for respondent number 2 has no objections. Learned PP Mr. V. Jimomi has also agreed to the prayer. Stop. Accordingly, list the matter after 2 weeks.
Much obliged, Lordship.
My Lord, please allow me to mention item 16.
16.
Here I am the appellant.
Yes.
I have served a notice through the upon respondent 2 and 3, which I'll be filing my affidavit on completion of service of notice during the course of the day.
Okay. Respondents?
I'm for the appellant upon
No,
2
no,
and
no.
3. Upon
2 and
respondent
3.
2 and 3.
Okay. Learned Counsel Mr. Parking Chapu appearing for the appellant submits that he has served notice by Dusty Mode on the respondents number 2 and 3 and therefore seeks some time to file the affidavit regarding the service. So list after 1 week.
2 weeks or 1 week?
If-
Respondent
if-
number
if-
1.
if I may, Lordship.
Yes.
Here I am for the respondent number 1, and they filed the IA for condemnation. So I will be filing my objection to that also.
Okay.
2 weeks maybe.
Learned Counsel Mr. L. Pump appearing for the respondent number 3. Terry Krill is appearing for respondent number 3. Has no objections. List after has no objections. List after list on 4th December. Yes.
Obliged, Lordship.
What about the other respondents? They have entered appearance.
I'm for the appellant, Lordship.
No, that's why. Other respondents, you are for respondent
Number 3.
3. So
Others
1
have
and 2
Yes, others
they
have
have
also.
call for scanned copy of the trial court records from the court of Learned Special Judge NTPS Kohima, Nagaland. List accordingly.
Obliged.
May I please, Lordship?
Yes.
Lordship, by order dated 24/7/2025, this Honorable Court has directed the state respondents to pay the contractual amount done by the contractor within a period of 2 months. However, more than 3 months have lapsed, and till date, no amount has been paid to the petitioner. Hence, this contempt petition. The order is at page number
Page 8.
8, next year 1. The relevant portion is at page number 11, paragraph 8.
This is an application under section 12 and 13 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, for initiating contempt proceedings against the condemners/respondents for willful and deliberate violation of this court's order dated 24/7/2025, passed in WPC 291/2024. So, para. Heard Learned Counsel for the petitioner, Miss
And repeal.
such and such. Stop. It is submitted that by order dated 24/7/2025, this court had directed the state respondents to release the payments due to the petitioner. Release the payments amounting to rupees 2,54,753 to the petitioner within a period of 2 months from the date of receipt of the order. Stop. It is stated that the state respondents the condemners/respondents are yet to release the said amount. Hence, the present petition has been preferred. Stop. Issue notice returnable within 4 weeks. The petitioner shall take steps for notice on the respondents number 1, 2, 3, and 4 by inland post, speed post, such and such, within 3 working days, as well as usual process within 3 working days Stop, list after 4 weeks.
Obliged, Lordship. Lordship, the matter is same, only the work order and the amount is different.
Order also same? Or,
The work order is different, Lordship.
oh, okay, okay. So same order, but here
Same
it will be order dated 24/7/2025 and WPC 292 of 2024. And the amount will be 6,20,200. Okay.
Much obliged.
Here also same respondents.
Yes, Lordship.
Yes, here also respondents 1, 2, 3, and 4.
Item number 4 to 7.
May I please, Lordship. Here, Lordship, the respondents were supposed to file affidavit, Lordship. However, they have not filed, Lordship.
Also got the respondent to file affidavit. Yes. Are you filing your affidavit? Oh, actually, the respondent 1.
Yes, Your Lordship.
Okay, okay. Who's appearing for respondent 1? None appears. Miss Esther appears for the petitioner and submits that the respondent number 1 was directed to file the affidavit by the order of this court dated 9/10/2025. Stop. However, the affidavit is yet to be filed by the respondent number 1. What about state respondent? Are you filing? Or
No, no.
the state is of Nagaland is represented by the learned PP Vijimani. Stop. None appears for the respondent number 1 today when the matter is called. Stop. List after 2 weeks. List after 2 weeks. In the meantime, the respondent number 1 is directed to file the affidavit.
Item number 9.
Yeah, please, Your Lordship.
Yes.
This is an application for bail. Lordship, charge sheet, case is already charge sheeted as early as 3/6/2025. And in spite of that, and cognizance also already taken, in spite of that, the bail was rejected twice in the learned court below. Lordship, the FIR was filed at Annexure A, page 11. A Sumudu FIR was filed in the officers in charge police station 1, Mokokchung. Thereafter, the accused person was arrested on 24th of May 2025.
24th of May.
Yes, 24th of May. Thereafter, Lordship, Lordship may kindly come to page 30, Annexure C. This is charge sheet number 6 of 2025, dated 3/6/2025, Lordship, on the dot.
3/6, yes.
Then it was submitted, Lordship may kindly see at page 34. Charge sheet number 6 of 2025, dated 3/6/2025, Lordship, it was forwarded on 5/6/2025 at page 34. Now, the sections under which the alleged accused person was charged is, Lordship, section 3, within bracket 5, of act by several persons in furtherance of common intention. Then 142, kidnapping, abduction, and threat to cause death or hurt. Then 3082, that is extortion. Then 352.2, intentional insult with intent to provoke breach of peace.
351.
351.2, yes. Then 111.2p, that is organized crime. Then Lordship, 7 NSR. Those are the charges, the alleged sections. Then, Lordship, the authorization letter will find it 35A, the wife is authorized. Then, Lordship, at page 36, on 17/6/2025, I'm reading from the third paragraph. Seen that the accused was arrested in 24/5/2025, such and such. Meanwhile, charge sheet has been filed under such and such on completion of investigation. Also saying that the present accused is involved in another case. He was arrested, but where bail is already granted. I'll have it annexed. The installed bail petition has been filed on medical ground. As per the medical report, the accused is stated to be suffering from headache and anxiety. The court, upon considering the matter, is of the view that the offences charged against the accused are of serious nature. As per the materials and report, the accused belongs to some proscribed organization. He is also involved in other criminal case. As per the medical report, the accused is stated to be suffering from headache for the past 3-4 years. However, the medical reports are of recent ones. As such, when the accused could allegedly commit a crime on 23/5/2025, it can also be safely presumed that accused illness is not of serious nature. There is every likelihood that the accused, if enlarged on bail, will abscond, considering the organization in which he allegedly belongs. This court is also of the view that the case of the accused really needs immediate medical attention. The same can also be provided under custody. Lordship, in second paragraph, the learned court below has made a clear recording that charge sheet has been filed, and this was also the second ground taken, but that was not considered when the bail was rejected. Then, my lord, at page 38, on 23/5/2025, are you, after case such and such, charge sheet against such and such? Apong M is the person, Lordship. The two persons are here, Olam Meran and Apong M. Apong M is the one who is. I have perused the charge sheet and material available on case record, and on finding sufficient materials to proceed, cognizance is taken for offense such and such. So, my lord, cognizance was taken. This is that. Then, Lordship, next at page 39. On 29/9/2025, again, bail was moved. The instant petition has been filed by the accused through such and such. Put the learned special PB for the state in the learned counsel for the accused are present and heard. Also bureaus the bail petition and arguments put forth by both the parties. The present bail petition has been filed subsequently to the dismissal of the bail petition by this order dated 17/6/2025. Seen that the present bail petition does not reflect any material change in circumstances as was when the bail petition was first moved before this court, there are no new facts or evidence that were not available during the earlier bail petition. The previous bail petition was also filed after the filing of the charge sheet in this court had dismissed the same, citing its reasons. There has been no change in the circumstances since then. The petitioner had also not adduced any new facts or evidence. The present petition is devoid of merit and accordingly dismissed. The Lordship, at page 40, by an order dated 4/4/2025, in the other case, that is where the petitioner was arrested, in the earlier case, he was already enlarged on bail, and that this has not been. In fact,
this is the Changtongya PS.
yes, Lordship. And here, Lordship, trial has already started and 3 defense witnesses already examined. I have made a categorical statement in paragraph 7.
In which case? This case or?
In this Changtongya's case, yes. Already now 3 prosecution witnesses had already been examined in this case. So that is the.
No, but in that he's already released on.
Yes, but just to bring it to the Lordship, because since in the first order, this was also reflected by the learned court below, that's why I'm bringing it to the Lordship notice that they're already enlarged in bail. And so, my Lord, then Lordship will kindly, my humble submission in paragraph 8, page 5. It is respectfully cited Honorable Msabuk in such and such. We are conscious of the fact that the accused are charged with economic offenses of huge magnitude. We are also conscious of the fact that the offense alleged, if proved, may jeopardize the economy of the country. At the same time, we cannot lose sight of the fact that the investigating agency has already completed investigation and the charge sheet is already filed before a special Judge CBI, New Delhi. Therefore, their presence in the custody may not be necessary for further investigation. We are of the view that the appellants are entitled to grant of bail pending trial on stringent conditions in order to allay the apprehension expressed by the CBI. It is also submitted that Honorable Court in such and such is held that in application for bail after filing of charge sheet, the nature of the allegations may not be a factor to decide if bail is to be granted. So my respectful submission, Lordship, the accused person is detained since 24/5/2025, now about 5.5 months. So in view of the fact that the charge sheet is filed,
Charge sheet filed 3/6, but charge not framed.
my lord, the last order in which I have enclosed, if cognizance is taken.
But this is by the
Page
CGM.
38.
This is by the
Page-
CGM. So
page 30.
isn't this sessions tribal? If kidnapping is there, then it
My lord, this is
142.
This is the order sent by the learned court from the down.
Because the fact that the sessions court is passing the bail
Yes.
orders means it's a sessions tribal case.
I also feel that way,
Yes.
but this is the
But-
CDC obtained.
But how the
But-
CGM
But
took
that,
cognizance?
my lord, that is for, I have not inquired about that, but the fact remains that charge sheet is filed, Lordship. There's no dispute that charge sheet is filed. So, because Lordship, filing of the charge sheet is clearly reflected in both the orders of the learned court below by the principal district and session judge.
Okay. It's fixed on 29/10
But you-
for framing of charge.
So it must have been filed, it must have been framed by now, Lordship. Charges must have been framed by now. So there's no question of tampering with evidence. Investigation is completed, Lordship. It is charged.
29/10, the charge was framed, and evidence is fixed on 14/11.
Yes. So day after tomorrow, by day after tomorrow, trial will start.
Yes, PP.
Mr. Lordship,
You are a resident of Mokokchung.
Lordship.
Yes,
LCR has been called for, so I have not seen the LCR. However, Your Lord-
that's
yes,
why I'm
yes, Your
looking at the
Lordship.
LCR. So charge has already been framed on 29/10,
Yes, Your Lordship.
and evidence is going to start from 14/11.
Lordship,
So now there's no need for the
Yes, Your
custody.
Lordship. Yes, Your Lordship. As far as Your Lordship granting of bail after the charges has been filed, Your Lordship. However, I have a little reservation because of the nature of offence that has been committed.
No,
It's
we'll give
serious in
some
nature.
stringent conditions.
Yes, Your Lordship, and also like belonging to an organization as well as apparent from the record, like he seems to be an habitual offender. So taking in those reservation, I have that.
No doubt,
otherwise,
two
yeah.
cases are there. One is going on,
Yes,
and
Your
the
Lordship.
other one is going to start now.
The alleged accused person is a permanent resident of Changtongya.
Okay.
Your Lordship, if this honorable court deems it fit that bail should be granted, Your Lordship, at least a government servant, Your Lordship, should be assured. Your
Not the
Lordship.
question of government
That,
servants.
Your Lordship.
Reliable bailer should be enough. Because
No, Your Lordship,
government
because
servant, my lord, why should we track our government servant everywhere?
No, he belongs to an organization, Your Lordship, and we have a very much apprehension that he will be
Some
absconded.
permanent residence
Permanent
certificate-
residence will be sufficient because
certificate, no, he's the accused permanent residence certificate attested by the council, village council.
Lordship,
it is very
Lordship, he is a resident of Changtongya
No,
town.
that's why.
So
that's
from
why.
the jail,
From there, from the town where he's residing. That
My
will
lord.
do.
my lord. Oh, for that matter, even from Hukchung town, any reliable bailer from
No,
Hukchung
the
town,
bailer will be from Bukchung town.
Lordship.
And then he also has to furnish the permanent residence.
Lordship, yes,
certificate.
fine, because
Your
he
Lordship,
belongs to my colony, so I know him.
Yes.
my
I know
prayer will
his
be
parents.
maybe
Yes,
reflected.
of
My prayer for surety for government servant.
Of course.
Your Lordship, because I feel that is deemed proper because he
Well,
belongs
let
to
it
an
be,
organization, Your Lordship.
Let it be a reliable bailer
Government
from,
servant, sometimes
situation.
the accused may know government servants, but some people may
A
not
family
know
member.
also. So there may be no family members also. You never know.
he is from Pom tribe,
We
so
need not
to
insist.
bring a government servant from Hukchung town may be difficult, so a reliable surety will be.
Yes, okay. Fine. The present application under section 483 BNSS has been filed by the wife, by
Yes,
the wife of the accused, Mr. Apong M, praying for release of the accused person on bail in connection with GR 12/2025 arising out of Mokokchung PS 1 case number 0006/2025 under section 140 clause 2/352 clause 2. No, in the cause title it's 352, but in the charge sheet.
Lordship, then let it be charged.
Yes, it's 351. 351 clause 2 /308 clause 2 /111 clause 2 B /3 clause 5 BNS read with section 7 NSR. Stop. Para learned senior counsel for the petitioner assisted by Mr. Sentilong. Stop. It is the case of the petitioner that the accused was arrested on 24th May 2025 in connection with the above mentioned case. Stop. After due investigation, the investigating officer has submitted the charge sheet dated 3/6/2025, and the same has been forwarded on 5/6/2025 to the court. Stop. Learned counsel submits that the custody of the alleged accused is no longer required as the investigation process is over and the trial has started. Stop. Para. Learned counsel has therefore relied on the case of Sanjay Chandra versus Central Bureau of Investigation, reported in 2012-1 SCC 40, wherein it is held that after completion of investigation and after the charge sheet is already filed before the court, the presence of the accused in custody may not be necessary for further investigation. Stop. Accordingly, it is prayed that it is also submitted that the accused is a permanent resident of Changtongya town, and therefore there is no chance of absconding or jumping bail if the petition is allowed, if the present petition is allowed. Stop. It is therefore prayed that the accused may be released on bail pending trial, subject to conditions imposed by this court. Stop. Para. Third learned PP, Ms. Vilivika, who has objected to the petition on the ground that the accused is a habitual offender and he is already booked in another case relating to the Changtongya PS case number. PS case number 1.
Yes, 1 of 2025. Relating to GR 5 of 2025.
Case number 1 of 2025 under section 305 small clause A BNS in GR 5 of 2025. Stop. It is also stated that the offense which the accused is charged with is of serious nature, and there is every likelihood that the accused may indulge in the same offense if released on bail. It is therefore
Your Lordship,
submitted-
also belonging to an organization, I have an apprehension that he will be.
It is also
Abscond, Your
stated
Lordship.
that the accused belongs to a banned organization, and then you continue every likelihood that he may commit the same offense. So, and learned PP has also submitted that in case the petition is allowed, the accused should be allowed to produce a surety who is a government employee. He's a government employee. Stop. Para. The court has considered the submissions of the learned counsels and also perused the case records which are produced. Stop. Trial court records, you say, not case record, trial court records. Stop. It is seen that the charge sheet has already been submitted on 5/6/2025, and cognizance has been taken by the learned CGM, and being Sessions Tribal, the case was committed to the learned Sessions Court. Stop. Thereafter, on 29/10/2025, the Sessions Court has framed charge against the accused person under section 142, the same ones, okay, you just repeat such and such. And the matter has been fixed for evidence on 14/11/2025. Stop. It is therefore seen from the records that the trial has already started, and this court is therefore of the view that the custody of the accused person is no longer required in the present case. Stop. Accordingly, the application is allowed. Stop. The accused, Shri Apong M, may be released on bail on the following terms and conditions. Stop. Number 1, execution of bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the trial court. Stop. The surety shall be a permanent resident of Mukokchung. Stop. Number 2, the accused shall appear before the court on every date fixed and shall not absent himself without showing cause. Stop. Next, the accused shall also produce a permanent residence certificate
From his ward authority.
from the authority of
Changtungya
Changtungya. Stop. Next, the accused shall not leave the jurisdiction of the trial court without permission of the court. Petition stands disposed.
Much obliged.
The registry is directed to return the trial court records.
Orders, item number 11.
Yes,
My lord, service upon respondent number 6 is awaited.
awaited.
Yes, your lordship.
No, tracking record shows that it is already served. Have you seen this?
No, your lordship.
Learned counsel for the petitioner, Ms. Atsila Gibbs is present. Stop. Learned counsel, Mr. N. Nangami appears for.
Respondent number 4, my lord.
Number 4. Stop. The As per Office Note dated 3/11/2025, notice upon respondent number 6 was issued on 9/10/2025, and the postal tracking report indicates that notice was delivered on 24/10/2025. Stop. However, despite notice, none appears for the respondent number 6 when the matter is called. What about the other respondents?
Lordship, the 1 to 3 is represented by V. Shokre.
Okay, stop. Ms. V. Shukri represents the respondent number 1, 2, and 3.
And 3, Your Lordship. I am for 4, my Lord.
Stop. Are you filing affidavit?
Your Lordship, yes, some time may be granted to receive the necessary instruction, my Lord.
Stop. Learned Counsel and Nangami appearing for respondent number 5.
4,
is it?
4, my Lord.
Prays for some time to file the affidavit in position in the present case. So how much time?
3 weeks' time, Your Lordship.
Stop. List after 3 weeks. So what about 5?
I think 5 is also, no one appears for 5 also, I think.
Five also, there's no service report. None appears for respondent number 5, and there is no service report either in respect of respondent number 5. Stop. We'll see in the next date list after 3 weeks.
Obliged, ma'am.
Obliged, my Lord.
Item number 12.
Yes, Your Lordship. Lordship, on behalf of my senior, Anunglal LKR, counsel for the petitioner. Your Lordship, my senior is out of station for medical treatment. Your Lordship, this amended petition in the contempt of COP 11 of 25 is filed via order dated 23/10 of 25. Your Lordship, the petitioner was allowed to file amended petition by implementing the new incumbent chief secretary to the government of Nagaland as respondent number 5 in the cause title. Your Lordship, in compliance to the Honorable Court Order 23/10/25, the amended petition is filed. Your Lordship, kindly issue notice upon respondent number 5.
Amended petition filed.
Yes, Your Lordship.
Learned counsel for the petitioner, MS such and such is present. Stop. It is submitted that the amended petition as has been filed by the petitioner in compliance with the, what was the last order? Where is it? Have you enclosed?
Yes, Your
Or-
Lordship.
By which order you were allowed to file the amended petition?
Your Lordship, order 23/10 of 25, Your Lordship, but it's not been enclosed.
23/10.
Yes, Your Lordship.
23/10. Or maybe in the IA it was allowed. IA, no?
Yes, Your Lordship.
That as allowed by this court in compliance of the order of this court dated 23/10/2025 in IA civil number 185/2025. Stop. Accordingly, the amended petition has been filed, and the respondent number 1, isn't it? Or respondent
Respondent
5?
number
Oh,
five.
Your Lordship.
and the newly impleted respondent number 5 has been inserted in the array of petition, in the array of respondents / contemners. Stop. Issue notice to the respondent, newly implemented respondent number 5. Stop. Returnable within,
1 week.
yes,
1 week, Your Lordship.
within 1 week.
Yes, Your Lordship.
I don't think that's possible. Within 2 weeks. Within 2 weeks. Stop. The petitioner shall take steps for service on the respondent number 5 by speed post as well as usual process within 3 working days from today. Stop. List after 2 weeks.
Much obliged, Your Lordship.
Oh, learned counsel Mr. N. Angami appears for
Respond number 1, my lord.
respondent number 1. Yes.
Lordship, in this contempt petition, I have instruction to appear for respondent number 1.
Number 1.
Yes.
Learned counsel for the petitioner, Mr. L. Pong is present. Stop. Learned counsel, Mr. N. Angami, enters appearance for respondent number 1 and prays for some time to file Vakra Nama.
Lordship,
as well as
and
the-
to receive necessary
as well as
instruction.
the affidavit. Stop. The office note dated 6/11/2025 indicates that service of notice upon respondents number 1, 2, and 3 is still awaited. No, respondent number 2 and 3 is still awaited. I think 3 has already retired, isn't it? Long time back. After her retirement, another 2 incumbents have taken over.
Yes.
If I'm not mistaken.
Yes, Your Lordship.
Lordship, if that
You
is the
check up.
question, can you?
Yes, anyway, what did I say? Service and notice has not returned on respondent number 2 and 3 has not returned. Has not returned, yes. So accordingly, this is the matter of the 3 weeks awaiting service on the rest of the respondents. Yes.
Right, Lordship.
Deeply obliged, my lord.
Item number 15.
Please, Lordship.
Yes.
Lordship, as per the order of this Honorable Court, I've served the notice upon the complainant, respondent number 2, through the office of the PP. And it appears from the office note dated 7 then that the affidavit to that effect has been filed by the office of the PP for service upon the respondent number 2.
No
So,
affidavit has been filed. No affidavit.
no affidavit.
6/11/2025, it says no affidavit has been filed with regard to service on R2. Who's the PP? Viji Momi. What happened to the notice on R2? You were supposed to serve through the police station, concerned police station.
The present matter is handled by my learned colleague, Tiba.
He's absent today.
He is absent. He has applied his leave note.
Okay, till when?
3 to 10 today.
Till today. Okay, we'll list it next week then, let's see. Because R2 has to be served, R2 is
Yes, yes.
necessary party.
If can be listed after 2 weeks, if he has to file affidavit, that yes.
Learned counsel for the applicant, Mr. Aaron Long is present, stop. The office note dated 6/11/2025 indicates that no affidavit has been filed by the PP regarding service of notice upon respondent 2. Stop. The learned PP, Mr. Momi is present, who submits that Mr. PP, Mr. learned PP, Mr. Tipa Pope appears in this present matter. So accordingly, this is the matter after 2 weeks. On the next date, the learned PP shall shall obtain instructions regarding the notice on the respondent number 2.
Much obliged.
Item number 17.
Please, Your Lordship. Lordship, here I am appearing for respondent number 1. I'll be filing my vakalat nama as well as my objection during the course of the week. So, if the matter can come up after 3 weeks.
Respondent 1.
1. The respondent claimant.
Learned counsel for the applicant slash appellate Taikril is present. Stop. Learned counsel, Mr. Such and such appears for respondent number 1.
1.
And submits that he may be given how much time? 3
3
weeks
weeks
time to file his objections to the IA 108K of 2025. So, office note dated 6/11/2025 indicates that service on respondent number 4 could not be verified. Stop. Accordingly, list the matter after 3 weeks. Stop. The learned counsel for the respondent number 1 shall file his objections. Stop.
Vakalat nama.
As well as vakalat nama. Stop.
Obliged.
Item number 19.
May it please Lordship. Also, the IA has been filed praying for implement of the new incumbent Home Commissioner Abhijit Sinha as respondent number 5 in the contempt petition.
Third, learned counsel for the petitioner, Mr. Moal Jamir. So, the present application has been filed for implement of the new incumbent Sri Abhijit Sinha IS, Home Commissioner, Nagaland, as respondent number 5 in the connected contempt petition number 22 of 2025. So, it is submitted that during the pendency of the contempt petition number 22 of 2025, the then Home Commissioner has been transferred and has been replaced by the new incumbent Sri Abhijit Sinha IS. So accordingly, it is prayed that the petitioner may be allowed to implead the new incumbent Home Commissioner Sri Abhijit Sinha IS as respondent number 5. As respondent number 5 in the contempt petition number 22 of 2025. Stop. In view of the submissions made above, the present application is allowed. Stop. The petitioner is allowed to complete the new incumbent Home Commissioner Sri Abhijit Sinha IS as respondent number 5 in the contempt petition number 22 of 2025. Stop. The petitioner shall accordingly file an amended cause title in the contempt petition 22 of 2025. Mr. V. Jimomi appears
For respondent number 4.
for respondent number 4. Have you filed your affidavit?
No.
Respondent number 4. He has also prayed for some time to file the affidavit on behalf of respondent number 4. So accordingly, list the matter after 3 weeks.
Obliged.
For item number 21.
May it please Lordship. Lordship, this revision petition has been filed challenging order dated 26/2025. It was passed in an IA arising out of an appeal which is pending before the Deputy Commissioner Chumukidan. And that appeal has been filed against an order passed by the Dobashi's court. It was passed in the year 2023. So there was a delay of 819 days. So
In filing that appeal before the DC.
exactly, yes. So while filing that appeal, I filed an IA for praying for continuation of delay of 819 days. That IA was rejected, being aggrieved and before the Honorable Court.
Depends what were the causes shown. Proper causes were shown.
Yes, in between I filed an appeal before the district judge, Dimapur, and that appeal was dismissed on the ground that it is filed before the wrong forum.
Oh.
Because in terms of the rules for administration of justice and police, it says that appeal has to be filed before the DC. That is the provision in the rules of 37. If your lordship may also kindly appreciate that this question of whether it is an appropriate forum or no, it has been referred before the larger bench, and which is also
Yes,
still
it is
pending.
still pending.
It's still pending. So the observation, my respectful submission is the observation of the London district judge saying that it is wrong forum that is yet to be decided. And that is also one of the grounds in my IA. May I read the impugn order?
Let's see.
Page 36. Page 36. This is dated 26/2025. This is passed in IA1 of 2024, arising out of Appeal 1 of 24. May I read it? Mr. So-and-so, appearing for the appellant, submitted that he had filed under Rule 5 of the Indian Limitation Act, read with Rule 29 of the Rules of Administration of Justice and Police, 1937, praying for continuation of delay in filing this petition of 819 days. This is important, 819 days. Learned Counsel submitted that a party had approached Principal District and Sessions Judge Dimapur and was dismissed, citing lack of jurisdiction. Moreover, being a village institution, had held various meetings pertaining to this issue. As such, took time for filing, so also submitted that limited prayer is made in the main suit, as such prayed to condone the delay. Mr. So-and-so rebutted the sufficient cost for continuation of delay is not prayed, and as such not sustainable. Learned Counsel relied on the ruling. This is the first ruling. May I read it from the next page? Limitation Act 1963, Section 5, delay continuation of sufficient cost, delay of 528 days in filing connected appeal. Plea that wrong forum was chosen to file the appeal and the actual delay was only 98 days. Explanation for delay held unacceptable, showing the total negligence in one bona fides. Delay caused only due to willful acts and negligence of the petitioner. In the case in hand, though the delay is filing the appeal is 528 days under so-and-so, it is only sufficient of the cause that matters and not the length and breadth of the delay. While delay with Section 5 application, the question of diligency of bona fide are to be considered. It is settled law that the length of delay is no matter. Acceptability of the explanation is the only criterion. Sometimes delay of the shortest range may be uncondemnable due to want of acceptable explanation, whereas in certain other cases, delay of very long range can be condoned as the explanation thereof is satisfactory. Admittedly, the petitioners in the council, without going through the provisions of law, properly filed the appeal before District Judge Imphal East with their own negligence, and delay caused in filing the appeal is only due to the willful act and negligence of the petitioner. Therefore, the court is of the view that argument of adoption of liberal approach of this court canvassed by the petitioners and to condone the delay in filing the appeal cannot be countenanced. Law assists those who are vigilant and not those who sleep over their rights. The petitioners cannot simply throw a blame on the council, and as a matter of right, they cannot seek for continuation of delay of a huge delay of 528 days in filing the appeal. In this case, yes, it has been admitted that they have approached the wrong forum and they were sleeping over their rights. That is the observation, and that is how the delay was rejected in this case. The second citation, which my learned friend referred in the while hearing, this is reported in 2024 to GLT Manipur 902. Limitation Act so-and-so, held 973 days in filing of review petition, no explanation for delay offered between the years 2017 to 19. Each and every day of delay not explained, applicant not approaching court with clean hands, prejudice caused to other side not to be brushed aside, sufficient cause not shown, review petition by other litigants on same issue dismissed on merits, application dismissed, petition dismissed. Admittedly, the aforesaid reasons stated by the applicants are not satisfactory. The aforesaid explanation of the applicants would itself show that they have not taken keen interest between the years 17 to 19 for filing the review petition. In fact, each and every day delay has not been properly explained by the applicants. While considering the application under Section 5, the court has to examine whether there was sufficient cause to condone the delay and whether the delay has been satisfactorily explained. In the state of Nagaland versus Lipok Ao and others reported in 2005-3 SSC 752, the Apex Court held that the expression sufficient cause should be considered with pragmatism in a justice-oriented approach rather than the technical objection of sufficient cause for explaining everyday delay. In the instant case, this is very important. The cause shown by the applicants herein is not sufficient to condone the delay. Further, each and every day delay has not been properly explained by the applicants, since the applicants have failed to explain the delay properly and the explanation given by them is not convincing, and also the fact remains that the delay is about 973 days. This has been wrongly incorporated. It is 819 days, not 973 days. This court has of the considered view that such an inordinate delay cannot be condoned. On overall analysis, this court is of the view that no sufficient cause is shown by the state for condonation of the inordinate delay. The question of state does not arise here. And also there are no valid grounds to review the order passed in read petition. There is no read petition pending. Being WPC number 546 of 2012. So this is not applicable in my case. Thus, the present miscellaneous case and the review application are liable to be dismissed. In the result, MC review petition number 37 of 2019 is dismissed. This is also not applicable in my case. This is wrong application of mine, total non-application of mine.
Which review they're talking about?
That is exactly. There's only one appeal pending before this appellate court, and that is appeal 1 of 2024.
Appeal 1 of 2024.
Yes. They have referred to two different cases, one writ petition and the other one is
What
review.
is this WP 546?
Exactly. So this is total non-application of mine. It was passed in a mechanical manner, in a routine manner, without application of judicious mind. Consequently, the review application SR is rejected. There will be no order as to cost. Heard the parties as land, perused the report submitted and observed that sufficient cause of delay is not established. IA 1 of 24 arising from Appeal 1 of 25 stands dismissed. So that was the observation.
How much time did you spend before the wrong forum? From the starting till the end? Dates?
DB's date 24/11/2021 is DB's court impugn order.
24/11?
2021.
2021.
And the appeal was filed before the district judge on 23rd May 2023. 23rd May 2023.
23rd May.
So within the intervening period.
23.
Yes. 23 May 2023, there is a delay of 545 days. 545 days.
Then after that,
And the appeal.
when was it disposed by the?
Yes, 26/5/2023. 26/5/2023. Within 3 days, it was dismissed.
26/5/2023.
5/2023. Yes. And the IA and the appeal was filed before the Deputy Commissioner on 22nd March 2024. This date is also very important. 22nd March 2024.
Before DC. When? 26?
22nd
Or 22nd?
March 2024. So on the date of filing, there's a delay of 849 days. 849 days. Counting from the Dobashi's court order till the time filing before the DC, Jumukirima.
No, 23/5 to 26/5 is okay because that was adjudicating before the wrong forum.
Yes.
But what about DB's court 24/11/21 to 23/5/23?
Yes.
Yes. How have you explained that?
There was an IA filed before the district judge. IA was also dismissed, explaining the delay.
Before filing the appeal?
Yes. Accompanying the appeal, there was also an IA. It is also reflected in the order, which was dismissed. May I take your lordship to the
Let us see
Order.
the orders now.
Okay, page 25, Lordship. This was the order passed in the first appeal by the district judge, Learned District Judge Dimapur.
25.
Page 25. This was registered as first appeal 1 of 23. May I read from the order? Present Mr. So the learned counsel for the appellant. I've also heard the counsel and perused the records. 2. This instant first appeal number 1 of 23 under Order 41 Rule 1 CPC, read with Rule 34 of the Rules of the Administration of Justice and Police in Nagaland, 1937 is preferred by the appellant, the Mova Village Council, against the impugned judgment in Order 24/11/21 bust by the Dobashis Court. Office of the Additional Deputy Commissioner, Metsi Pema, in case number 1 of 20/64/2021. Para 3. In Kevidakthi Sesa versus State of Nagaland and others for others, Civil Revision number 5 of 2020, wide judgment and order dated so and so, the High Court, the Gauhati High Court held at Para 23 and 24 as under 23. Thus, in the considered opinion of this court, the district and sessions judge has not been conferred with the necessary jurisdiction required to take the appeal in question filed under Section 96 of the CPC, read with Rule 31 of the Rules 1937. Therefore, the district and sessions judge is not having power and jurisdiction to adjudicate an appeal from the decision of the customary court and accesses power either under Section 96 of CPC or under Rule 41 of or Rule 31 of the Rules of 1937. It is clear that no special enactment has been made conferring any jurisdiction upon the district and sessions to exercise power under Rule 31 of the Rules of 1937. A conjoined reading of the notification dated so and so reveals that for the purpose of protecting the services of the existing Deputy Commissioner, the said notifications were issued in as much as they were brought under the administrative control of Gauhati High Court. Therefore, the considered opinion of this court is that such absorption and change of nomenclature shall be automatically vest jurisdiction to appellate authority upon all the district and sessions judge in the state of Nagaland, with the power and jurisdiction of the appellate authority under Rule 31 of the Rules 1937 and Section 96 of CPC or Order 41. May be noted that in the aforesaid case, the Gauhati High Court had disagreed with the judgment in order dated so and so passed by coordinated bench in so and so. The matter was placed before the Honorable Chief Justice for referring the issue to a larger bench. Para 4. Thus, in view of what has been held aforesaid in so and so, this court has no jurisdiction to entertain the appeal against the judgment in order passed by the DB's court, office of so and so, so and so. The instant appeal number so and so is hereby dismissed and disposed of accordingly. Along with the appeal, the appellant has also filed IA number so and so and IA number 34 of 23, praying for continuing the delay in filing the appeal and praying for stay of the operation of the impugned order respectively. For the aforesaid reason, both the IA are also hereby dismissed and disposed of accordingly. So apparently there was an IA praying for continuation of the delay.
No, actually, the district judge should have kept it pending till the disposal of the reference case.
Exactly.
Yes.
So since I was directed to approach the appropriate forum, and since on approaching the London district judge.
Again, if the reference bench says that it can be appealed before the district judge,
exactly. I'll have to go back again.
Because I remember many appeals like this came up before me also when I was district judge Kohima, and we have kept everything pending till the disposal of the reference case.
That should have been the appropriate direction at that relevant point of time, but unfortunately, my appeal was dismissed along with the IA.
But here you have challenged only the order of the DC Chumukudima, isn't it?
Yes, yes.
Okay. Then after this, after this you file this IA and the appeal.
Yes. In fact, to dismiss my IA by the DC Chumukitima, it took more than a year. They have kept it pending because I filed on 22nd of March 24. It was dismissed only this year, June 2025. They kept it pending for more than a year, and now they of the opinion that no, you have not explained the delay sufficiently.
See, the courts, regular courts are regulated by CPC, and we have to go by the CPC and the Limitation Act. But as far as the customary courts are concerned, strict appliance of the Limitation Act or CPC is not there. Only spirit may be applied. So the ADC should have just condoned the delay, because the wrong forum was also there. Plus something was there, some, what do you say, procedural lapses were there.
Yes, Your Lordship, since it's an application for condemnation of delay, as my learned counsel was submitting, that in such condemnation application, it's not about the length or the delay period. The only most important thing is that whether if the delay is for 1 day, that 1 day delay has been properly explained or not.
Yes,
Here,
that willful negligence and all that diligence, whether diligence.
that is what, since it's an application for condemnation of delay. First of all, Your Lordship, I would like to draw the attention, page 3 of the civil revision petition, page 23, that is Annexure D. Here at last paragraph, it clearly says, page 23, Your Lordship, of the civil revision petition. This is the first order of the Dovashis Court.
The Dovashis.
Yes. So that last paragraph, I may be allowed to read, Your Lordship. Any aggrieved party may appeal to higher authority within 10 days. And here, in this petition, if we go by the plea of this petitioner village, basically there are only two pleas. Number one, that due to technical procedures, they were not aware. Secondly, advocate was not pursuing their matter diligently. So first of all, here the petitioner village, who is representing this petitioner village, its chairman. Now can we say that he is illiterate person? Here in the order, it is clearly written that within 10 days. So as my learned counsel also pointed out that, first of all, there was a delay of 545 days before approaching civil regular court. And in that application also, they have not properly explained why there was such delay. Secondly, then even after dismissing from there, before then they have approached this Chumukdima DC. Again, there is a delay period. Now, how could they explain that? And all the petitions, the first petition which was filed before the regular court, that IA for condemnation, as well as the IA which was filed before the DC Chumu, and here before this honorable court, there is nothing new, no explanation. All the grounds are as it is. So whether this court would presume that the petitioner village was pursuing the matter diligently, and whether this court can admit that because of these technical procedures, because as per law, ignorance of fact is excusable, but ignorance of law is not excusable. Then if that is the case, then any layman can say that, oh, this is the law of our land, I was not aware, so I may be excused. So there is nothing. They have not explained properly, and as per this latest judgment of the Honorable Supreme Court, which was passed in this September only. All these previous judgments were overturned, and now this latest judgment says that in continuation petition, not only the delay period, the time from when this continuation period begins, limitation period, that has also to be explained. In this case, forget about explain that limitation period. Even after this limitation period was expired, they have not explained anything which this honorable court can presume that, okay, the petitioner village was pursuing the matter diligently as well as pursuing the matter sincerely. There is nothing, Your Lordship. And in this kind of application, as I'm reiterating that, it's not about how many days or it's not about the length of delay, whether proper explanation has been given in the petition or not. All the three petitions, right from the civil regular court to DC Chumu to this before this honorable court, all the grounds are same as it is. By the way, in condemnation petition, it's not about the merit of the case, but still I would like to apprise the honorable court, what is the issue here? I have bought a plot of land there at Mova village. Now I'm trying to construct my residential house. Now they are saying that since there is a village council resolution, it's an agricultural land, you cannot build your own house in your own plot of land. And when I bought this plot of land, there was no such resolution. This is the issue in this case. And they are saying that if I build my own residential house in my own plot of land, it will destroy the traditional culture of the Mava Village Council. Now it is beyond imaginable if I build a house and it will destroy the village council's traditional culture, How it is correlated, this is beyond my understanding, Your Lordship. This is the issue in this case.
You had bought a terrace field.
Yes.
And you wanted to build a house there.
Yes. And they are obstructing me, saying that it's an agricultural plot of land. I cannot build my own residential house. And the plea is that it will destroy their tradition and culture in the Mawa Village Council. What kind of logic is this? This is beyond my understanding. This is the issue in this case, Your
From the
Lordship.
date of the DB's judgment, 26/2025 to 23/5/2023, what was the explanation? I don't find any valid explanation.
Yes, Lordship. My explanation is only in the page number 33 of the IA. This petition, the IA will be page 6, review petition will be page 33, para 7.
No, this is only regarding your filing before the ADC.
Yes, yes.
But before that, 545 days delay is already there.
Yes.
Before coming to the district judge also.
Yes, yes.
So that delay has not been explained at all.
Yes. Yes. I agree that.
Yes. Because that is the main thing. Because the court may be inclined to condone the delay spent before the inappropriate forum.
Yes.
That is okay. Before
Yes.
wrong forum, the court may be inclined to condone the delay. But from 24/11/21 to 23/5/23,
Yes.
there is no explanation.
Yes. I have instructed my clients to obtain a copy of the IA which was filed before the district judge, district judge, and how the delay was explained, because I cannot explain.
Different counsel
Yes,
was
yes,
there.
yes. So, but unfortunately, the records were not available.
Records were not available.
Yes.
In the present form,
Lordship,
how can the court help?
I have gone through that IA also. There are sections. There is nothing. That is what I'm saying, that the contents of that IA and the contents of the IA which was filed before the DC Chumu, and here in this application also, all are more or less same. Only due to technical procedures and advocates were not pursuing the matter diligently. That is the only two grounds.
Or if the records of first
Will it be
appeal.
available? If you have not got it, then if the court calls for the record, will it be available?
I try to get it only through my client. If proper direction may be issued by the sort of court calling upon the reports, because I'm yet to peruse even the contents of the IA, how the delay was explained by the earlier counsel.
Lordship, would like to draw the attention of my affidavit in opposition, that is page 37. Actually, we were also, after opening this only, we came to know after seeing the contents, that is page 37. Page 37, Annexure 3. Then page 38, Your Lordship, the title course.
Acha, this is the IA.
Yes, but here, fairly I'm admitting the fact that it was their mistake. Here in the course title, it says an application under Section 5 of the Limitation Act 1963 praying for continuation of delay. But if we go to the last page of this IA, which they had filed before this district judge, here they are praying for staying of the impugned order which was passed by the Devassis court.
As to why the impugned order should not be stayed. Oh.
Yes.
No, this appears to be from a different petition, different application.
No, same, Your Lordship. It's same.
Two different IAs were filed.
There were two different IAs. One is IA 33 and one is IA 34. So might be mistakenly title they have written here like this, but that another IA, which is IA 33, that might be for condemnation. And I have gone through the contents of that IA 33 also.
Title is like that, but
Yes,
the
yes.
contents are different.
Yes,
Contents
yes.
are for stay.
Yes, and that for condemnation, the contents is there at IA 33.
So that IA 33, you do not have a copy.
No, Your Lordship, actually when obtaining this copy, I have only seen this title course without going the contents. While preparing yesterday only, I came to know that it might be mistake on their part. In title course, they have prayed for condemnation, but in prayer they are saying for staying of the impugned order.
That means the limitation application must be that 33.
33, yes, yes.
Records were never called for. Trial court records were not called.
No.
Let's try once, call for the records
Lordship.
from the district judge. Yes. Heard learned counsel for the petitioner, Mr. Mual Jamil, as well as Mr. P. Suryan for the respondent number. So
One and two?
respondent.
Yeah, no, two. I'm representing both the
Respondent
respondent.
number 1 and 2. In the course of hearing, it has come to light that the trial court records will be required for adjudication of the present case. Stop. Accordingly, the registry is directed to call for the records of
Page 25, Lord.
page 25. Records of first appeal number 1 of 2023. 1 of 2023, along with IA 33.
Yes, 33 and
IA 33 of 2023 and 34 of
34 is already there. I have enclosed.
IA 33 of 2023. from the Court of Principal District Judge, Dimapur, Nagaland. Stop. You say scan copy. Or but since it's disposed,
Yes,
you
yes,
call
yes.
for the records, okay? The court records. First episode reserved from the Court of Principal District Judge, Dimapur, Nagaland. So, list after 3 weeks.
Notes.
List after 3 weeks.
Obliged, Lordship.
Ini kan nolore.